Roe v. Wade is a case that is still in the minds of Americans and has made headlines multiple times since its happenings back in 1970.
It all started with a woman who for the purposes of the case is referred to as Jane Roe. I'm guessing it's because there are too many Jane Does around and it would have gotten a bit confusing. Anyhow, she filed a lawsuit against a man named Henry Wade, a lawyer of imposing stature and a balding head. He also happened to be the district attorney of Dallas County, Texas, Jane's home state. Yeehaw. Something didn't quite sit right with Miss Roe when she looked at the state's current law regarding abortion. It stated that it was illegal unless under orders of a doctor to save the soon-to-be mother's life. Her argument was that these laws were vague and abridged her rights of personal privacy, so naturally, it was taken to court.
Spoiler alert, she won. It was ruled that the Constitution protects a woman's rights to an abortion without excessive government interference and restriction. This ruling highlighted the fact that the Constitution protects women's rights to an abortion, making it a landmark Supreme Court case. Justice Harry Blackmun delivered the opinion of the court since he was one of the majority ruling, which addressed the mootness of the case in the final verdict. But let's take a moment to look back and reflect what went on before this long-awaited outcome. What is the Due Process Clause of the 14th Amendment? Maybe it's the process of turning in an assignment on time. You know, when it's due. No, I don't think so. I know. It is quite literally the fundamental right to privacy that protects a pregnant woman's choice whether to have an abortion.
So what's the problem here? Why is this even a case?
It's because the government has the power under this clause to basically toss it to the side if it deems that the life of the woman or potential child is in danger, which then leads us to look at what the government can and can't do during a woman's pregnancy.
I know this one. In the first trimester, the state cannot do a thing. It's up to the mother and her physician. In the second trimester, the state can impose regulations that are reasonably related to maternal health. However, in the third trimester is when things get dicey. This is when the state has the right to regulate abortions or simply prohibit them entirely. So yes, this is the story of Miss Jane Roe and her bald opponent, Mr. Wade.
Now, with every story comes some key vocabulary, of course. What the heck is an oral argument, and who played this part in the case? As you may have guessed, it is an argument, but not one with yelling and crying, usually. It is a presentation of a side of a case that happens by speech in court, so no long paragraphs written to the judge, folks. In this case, the oral argument was made by attorney Sarah Weddington, who represented Miss Roe. It states that the ruling declared the law to be unconstitutional, and that it violated a woman's right to determine to continue or terminate a pregnancy. This is the perfect example of an oral argument as it relates to Roe v. Wade. Who are the law clerks?
I know. Are they clerks of law?
Actually, yes. They're the superfluous secretaries of the courtroom. Their duties include research, preparing memos, and proofreading what the judge writes. In the case of Roe v. Wade, Harry Blackmun, former Associate Justice of the Supreme Court, revealed in his papers that he gave large portions of control to his law clerks over his thinking and writing when he was on the Supreme Court. Blackmun's clerks played substantial roles in producing his opinions as early as 1971, when the landmark abortion cases first came before the court.
Continuing on this topic of important people in court, I bet you don't know what a Solicitor General is.
Actually, you couldn't be more wrong. As the extremely prepared and organized person I am, I actually researched who this was for Roe v. Wade. Firstly, it is important to know that they're the fourth highest ranking official in the United States Department of Justice. They're the people responsible for arguing cases before the Supreme Court. Irwin Griswold was the Solicitor General of the United States in 1970 during the time of this case.
Well, I bet you don't know who had a concurring opinion in the case.
Since a concurring opinion is one that agrees with the majority ruling but has a difference in opinion, an example would be Justice William O. Douglas. He believed that it was correct to protect abortion as a fundamental right, but argued that using the Ninth Amendment would have made more sense, since this amendment deems that even if rights aren't specifically stated in the Constitution, they still may be powers that people possess. Which makes sense if you think about it relating to this case, since the Constitution mentions nothing of abortion, and yet that right is still protected.
Well, that makes sense. But what about the opinions of those in the minority, the dissenting opinion?
Those definitely come into play here. Both Justices White and Rehnquist dissented from the court's decision. White believed that the court had no basis to make a case regarding abortion and argued that the legality of abortion should be left with the people and the political process the people have devised to govern their affairs. Rehnquist stated from his point of view that the drafters did not intend to have the 14th Amendment withdraw from the states the power to legislate with respect to this matter, since there apparently was no question concerning the validity of this provision or of any of the other state statutes when the 14th Amendment was adopted. Now, I've got a question for you.
Oh boy.
Firstly, do you know any Latin?
Can't say I do.
This will be fun. Do you know what an amicus curiae brief is and how it relates to this very case we are discussing?
Actually, I do. It is where someone who is not a party to the case offers the court support and information in the form of a brief. I know you were sitting there all sad wondering how I know that, but it's not all I know. It relates to our case because there were 42 briefs filed in support of a woman being able to choose to have an abortion. Take that.
Okay, let's make this a little harder. What is a conference?
Like a business meeting?
Kind of.
It's a joint committee of the United States Congress set to resolve disagreements on a particular bill. An example could be when the court was discussing whether or not they would grant the writ of certiorari. Speaking of which, I've got one last question for you. Do you know what a writ of certiorari is?
Of course I do. It is the order to a lower court to deliver information on a case so that the higher court may review it.
Anything else?
Nope.
Well, unfortunately, there is more. In relation to our case here, they had trouble granting this for Miss Rowe because by this time she had already given birth and given up her child for adoption. Therefore, she was no longer being affected by the case. However, despite this, the court still granted the petition for certiorari. I finally won.
This wasn't a competition, you know.
You are right. Well, on that note, it's time for us
To say goodbye.
Bye.
Wale, that's Latin for...
I know!